Good day viewers, welcome to another edition of the Daily Strange Stories. I'm John Brown. I hope you've had a productive and fulfilling week. Now, let's dive into the strange and unusual. Our lead story for today. One deadly blunder, end of the road for Senzo Mchunu for disbanding political killings task team as SAPS legal boss Major General Petronella van Rooyen nails him at Madlanga Commission. Matlala's blue lights get EMPD chief in hot soup, begs for immediate special leave as the situation gets tense. What happens when the very people meant to protect us become the ones under suspicion? South Africa is grappling with this critical question as Police Minister Senzo Mchunu faces serious allegations of abuse of power and interference in police operations. Did he make a fatal mistake, a move that could cost him his career, by disbanding the KwaZulu-Natal political killings task team? Major General Petronella van Rooyen's testimony suggests he did, and the potential implications are staggering for the entire nation. Meanwhile, hundreds of kilometers away in Egurhuleni, Acting Chief Julius Mkhwanazi's questionable relationship with businessman Vusimuzi Matlala raises even more disturbing questions about who is really in control of law enforcement and whether justice is truly blind in South Africa. As tensions rise, Mkhwanazi has urgently sought special leave, stepping aside amid calls for his suspension and investigations that could unravel more layers of misconduct. The Madlanga Commission of Inquiry, established by President Cyril Ramaphosa, is probing serious claims made by KwaZulu-Natal Provincial Police Commissioner Lieutenant General Nhlanhla Mkhwanazi in July 2025. These claims suggest that criminal syndicates with ties to politicians, prosecutors, and even judges have infiltrated the top levels of the police service. The commission, led by retired Constitutional Court Justice Mbuyiseli Madlanga alongside advocates Sandile Khumalo and Sesibaloi, is tasked with examining whether Mchunu's orders to disband the task team were lawful, classifying them as directives, policy decisions, or operational intrusions. The outcome holds significant weight, as it could influence Ramaphosa's decisions on Mchunu's cabinet position and clarify the boundaries between ministerial oversight and police operations. Major General Petronella van Rooyen, in her role overseeing governance, legislation, and policy for the police service, has become a pivotal figure in this inquiry. During her appearance on Thursday, the 25th of September 2025, she firmly stated that Mchunu lacked the legal authority to disband the political killings task team. She bases this on Section 207 of the South African Constitution, which grants the National Commissioner exclusive control over managing the police service.
The powers and functions of a Minister of Police in South Africa are primarily defined by the Constitution as discussed above and in terms of the Police Act. The Minister's role is to provide political oversight and to determine national policing policy, while operational control of a police service is vested in the National Commissioner. The Minister's key powers and functions involve the following. The Minister is responsible to formulate national policing policy in consultation with the provincial governments. This ensures an overall strategic direction of a police. This ensures that the overall strategic direction of a police service is aligned to national priorities in accordance with Section 206 of the Constitution. And in this regard, it should be noted that the Civilian Secretariat for Police Service has drafted various policy documents for approval by the Minister. It includes, for example, a policy on the reduction of barriers in the reporting of sexual offences and domestic violence. Government's policy does not only relate to the decision or view of a President and a Minister, and this is even more pertinent in view of our current government of national unity. So it cannot be proposed that even if it was discussed with the President, it has now become government's policy or government's intention to dissolve the PKTT. Clearly, it was an instruction by the Minister. It also contained the word, I believe repeatedly, direct. The question is, was it a lawful instruction or direction in the sense that the Minister have the power to direct or command the closure of a task team that was investigating crimes? And in my view, he did not have that authority. because it relates to the operations, investigating cases and the operations of the police. In other words, the execution of the police's mandate in terms of Section 205(3). If we say the National Commissioner is responsible to manage and control the police service, that must be linked to manage and control the police service in the execution of its constitutional mandate. And the decision of a minister to close a political task team that was responsible for the investigation of crime, in my view, fell outside the mandate or authority of the minister.
So in short, what may be purporting to be a Section 2072 direction cannot be such a direction if it has strayed onto operational matters.
I agree with that submission or with that explanation, Chair.
Van Rooyen argues that disbanding the team falls under operational matters, not policy, and that Mkhwanuzi's directive represents an unlawful intrusion into the National Commissioner's domain. She emphasizes that ministers handle broad policy directions, while day-to-day decisions like task team operations remain with police leadership to prevent undue political influence.
Based on the legislative excursus detailed above, I am of the view that the decision to disband the PKTT as a task team lay within the exclusive authority of the National Commissioner, and that the Minister did not have the legislative authority to disband the PKTT, let alone the manner in which he did. I say so for the following 6 reasons, one of which is in the alternative. Firstly, Section 206 of the Constitution enshrines the role of a minister primarily as that of providing policy direction at the national and provincial level. The Minister of Police is not a technocrat. His or her role is to advance the development of legislation and national police policy, particularly in respect of key issues that require executive attention. Therefore, a minister is empowered to select which areas warrant specialized intervention and attention, such as cash in transit, illegal mining, gangsterism, etc. However, a minister cannot prescribe or direct at an operational level, how policy is to be implemented. That is to be left to the National Commissioner, especially in view of the fact that this relates to the distribution and deployment of resources and has financial implications, which falls within the exclusive authority of the National Commissioner as the accounting officer of the Department of Police in terms of Section 36 of the Public Service Management Act. The Minister unlawfully strayed into the constitutional competence of a National Commissioner when he issued a letter for the disbandment of the PKTT. What would have been an appropriate path is for the Minister to express that he no longer considers political killings to be a priority and direct the National Commissioner to consider and take steps to align it with his directive. It can never be appropriate for a Minister to instruct the National Commissioner not only to disband the PKTT, but also to say that the disbandment must be done immediately. That constitutes not only an usurping of powers of a National Commissioner, but also undermines the constitutional objects of the SAPS as set out in Section 205(3), especially in respect of ongoing criminal investigations and the potential risk that further crimes may be committed. Thirdly, due to the nature of the offences under investigation, a task team like the PKTT is privy to politically sensitive materials, and its dockets would need to be treated with the same sensitivity. The dockets could not simply be taken back to their respective police stations and investigated in the normal course. I say this because politically related cases are highly organized and are executed through different role players, such as hitmen, spotters, coordinators, and persons who ordered the hits. In addition, they typically involved a conspiracy implicating well-resourced senior politicians
This testimony aligns with earlier statements from National Police Commissioner General Fanny Masemola and KwaZulu-Natal's Nhlanhla Mkhwanazi, making Van Rooyen the third high-ranking official to accuse Mchunu of overreach. Masemola has described receiving a letter from Mchunu on the 31st of December 2024, directing the immediate disbandment of the task team, claiming it no longer served a purpose in combating crime. Masemola countered this by pointing out that political killings continue to occur, far beyond the pre-1994 era that Mchunu reportedly referenced as the only relevant period for such incidents. Van Rooyen builds on this, noting that such a directive not only usurps powers but also undermines the constitutional goals of the police service, potentially allowing crimes to persist unchecked. The implications of Mchunu's actions extend to the handling of specific cases. Following the directive, Deputy National Commissioner Lieutenant General Shadrack Sibiya, now suspended, took steps to deactivate the task team on the 17th of January 2025, despite lacking approval from Masemola. Sibiya withdrew 121 case dockets from the team and relocated them to the police headquarters in Pretoria, where they sat idle for 5 months. Van Rooyen highlights the alarm this raises, as the stagnation of these investigations could lead to lost evidence, faded witness memories, and the continued circulation of items like firearms that might be linked to ongoing crimes. She stresses that any instruction to move these dockets should have come directly from the National Commissioner, not a deputy acting on ministerial orders. Furthermore, she references Section 199 of the Constitution, which prohibits security service members from following manifestly illegal orders, underscoring that Sibiya's actions were problematic from the start.
It is important to highlight that in his letter, the Minister did not direct how the dockets under the task team's control should be dealt with. He did, however, direct that the disbandment ought to be done with immediate effect. I am informed that this determination of the dockets under the task team's control should be dealt on how the dockets to the task team should be dealt with was made by Lieutenant General Sibiya in his letter to Lieutenant General Sintamule, dated 4 February 2025. That letter also makes clear that Lieutenant General Sibiya claims to be acting on the instruction of the Minister of Police to disband the task team. And that letter is also part of my file too. The affidavit, the post...
So can I just ask you maybe...
General, focusing on the prescripts, we know what General Masemola said and what General Mkhwanazi said. Is it consistent with any prescript that you are aware of, whether it's the national instructions or other directives? Is it consistent with any of those for dockets to be taken from a province or a unit or a task team and be stored at national office for a period of up to 5 months without any investigations taking place?
No, Commissioner, it is not. And I think the first reason that raises alarm is it means the investigations are stagnant. Nothing is happening. On that investigation, you would expect the police to proceed as fast as possible and make a breakthrough. But the longer the dockets remain unattended, the more difficult it becomes to investigate that cases properly. Evidence get lost, witnesses forget with time, and therefore the investigation, any investigation, will be detrimentally affected if it is stored somewhere and no attention it doesn't receive attention in the furtherance of the investigation. Based on the legislative excursus detailed above, I am of the view that the decision to disband the PKTT as a task team lay within the exclusive authority of the National Commissioner, and that the Minister did not have the legislative authority to disband the PKTT, let alone the manner in which he did. I say so for the following 6 reasons, one of which is in the alternative. Firstly, Section 206 of the Constitution enshrines the role of a minister primarily as that of providing policy direction at the national and provincial level. The Minister of Police is not a technocrat. His or her role is to advance the development of legislation and national police policy, particularly in respect of key issues that require executive attention. Therefore, a minister is empowered to select which areas warrant specialized intervention and detention, such as cash in transit, illegal mining, gangsterism, etc. However, a minister cannot prescribe or direct at an operational level, how policy is to be implemented. That is to be left to the National Commissioner, especially in view of the fact that this relates to the distribution and deployment of resources and has financial implications, which falls within the exclusive authority of a National Commissioner as the accounting officer of a Department of Police in terms of Section 36 of the Public Service Management Act. The Minister unlawfully strayed into the constitutional competence of a National Commissioner when he issued a letter for the disbandment of the PKTT. What would have been an appropriate path is for the Minister to express that he no longer considers political killings to be a priority and direct the National Commissioner to consider and take steps to align it with his directive. It can never be appropriate for a Minister to instruct the National Commissioner not only to disband the PKTT, but also to say that the disbandment must be done immediately. That constitutes not only an usurping of powers of a National Commissioner, but also undermines the constitutional objects of a SAPS as set out in Section 205(3), especially in respect of ongoing criminal investigations and the potential risk that further crimes may be committed. Thirdly, due to the nature of the offences under investigation, a task team like the PKTT is privy to politically sensitive materials, and its dockets would need to be treated with the same sensitivity. The dockets could not simply be taken back to their respective police stations and investigated in the normal course. I say this because politically related cases are highly organized and are executed through different role players, such as hitmen, spotters, coordinators, and persons who ordered the hits. In addition, they typically involved a conspiracy implicating well-resourced senior politicians.
This chain of events has broader consequences for justice in KwaZulu-Natal. The Political Killings Task Team was specifically formed to address targeted assassinations linked to political rivalries, a persistent issue in the province. By disbanding it abruptly, Mkhwanazi's decision delayed progress on cases affecting families seeking closure. Van Rooyen points out that if political killings were no longer deemed a priority, the proper approach would have been for Mkhwanazi to advise the National Commissioner to realign resources, rather than issuing a direct command for immediate shutdown. This distinction is crucial, as it preserves the insulation of police operations from political pressures, ensuring that investigations proceed based on evidence and need, not external influences. The Commission's work also touches on parliamentary oversight failures. Van Rooyen notes a March 2025 meeting of Parliament's Police Committee, attended by both Mkhwanazi and Nhlanhla Mkhwanazi, where issues similar to those now under scrutiny were discussed. She expresses concern that the committee did not follow up with investigations or calls for explanations, viewing this as a lapse in their mandate to ensure accountability. Instead, it took Nhlanhla Mkhwanazi's public briefing in July to prompt action, leading to the Madlanga Commission and a planned parallel ad hoc committee in Parliament, set to begin hearings next month. This delay highlights systemic gaps where oversight bodies fail to act proactively, allowing potential misconduct to fester. Adding another layer to the narrative is the involvement of suspended Police Minister Senzo Mchunu in other alleged interferences. Reports have surfaced about his attempts to influence a by-election in Gwaduguza municipality by targeting MK Party councillor Doshi Gaddafi Governor. According to details shared at the Commission, Mchunu reportedly met with a North Coast Station commander, Major General Anthony Gopal, to discuss a case aimed at arresting Governor just days before the April 2025 by-elections. Governor, who had switched from the ANC to the MK Party amid claims of discrimination, learned of the plot through a senior ANC official who tried to persuade him to withdraw his candidacy in exchange for positions in the municipality. This incident, as relayed by Nhlanhla Mkhwanazi during the Commission's third day on the 19th of September 2025, illustrates how Mchunu allegedly used police resources to sway political outcomes, further eroding trust in law enforcement's impartiality.
What had happened here, there was going to be by-elections. A person who was a councillor had resigned from the position. And that person, for whatever reason they were having in that political party, he resigned and he joined another political party. So he was campaigning for another political party. So the minister then came into the area as a deployee of his party to assist the campaigning of another candidate to be elected. So part of his, when he arrived, he requested, actually he didn't even communicate with myself, nor Gerald Kopal, he communicated with the station commander. He said to the station commander he wants to meet the station management at the police station because he wants to ask them about a case. The case allegedly that involves the councillor that had resigned from this side and moved over campaigning for another political party. So the minister was entrusted to know what is happening with that case because this man has got a case. So, which means they wanted to make sure that he's arrested so he doesn't stand for the other party. So the minister called the station management. The station management communicated to Gerald Kopal. Gerald Kopal was sitting with me and he told me about it. And I said, I think you better go there. The minister cannot see it with the station management alone. Go there and find out what's going on. And at the same time, the station had already informed Gerald Kopal on what the minister's specific cases that he wants them to come and account to him about. Remember, he came there for campaigning, for election. But he wants the station to come and explain to him about the status of the case against a competitor for the election. So the station must brief him about it. Gerald Kopal obtained information with regard to the status of the case. So he went to a meeting. I guess the minister was surprised when Gerald Kopal landed there. That the minister suddenly, he meets Gerald Kopal, is not only station management alone. And then he inquires about this candidate. Unfortunately for the people that are of that political party that minister belongs to, they had a mistaken identity. They thought the case that was opened was against a candidate, but it was against the candidate's brother. Missed target again, like the PKTT and GCI. They missed the target there. And they realized that their complaint is unfounded. But beside that, there was a case. The feedback was given there, which was satisfactory with regard to the status of the case. Although it didn't concern them, but they were told, okay, the case is like this. But the question was, Minister, why would you want the station management to come in account to you about a specific case that involves a person who's competing with you in the political space? So which means if there was a case against this person, he was going to put pressure to the station management to make sure they arrest this person before the local elections that were going to take place.
Shifting focus to the Ekurhuleni Metro Police Department, Acting Chief Brigadier Julius Mkhwanazi, distinct from the KwaZulu-Natal Commissioner of the same surname, has found himself entangled in the scandal through his alleged connections to Vusimuzikat Matlala, a controversial businessman facing attempted murder charges. Matlala, often described as a tenderpreneur with deep ties to various networks, reportedly received undue privileges from Egurhuleni's law enforcement. General Mkhwanazi testified last week that Julius Mkhwanazi facilitated the registration of 4 or 5 vehicles belonging to Matlala under the municipality's name, using government funds to cover the costs. This made the vehicles appear as official municipal property in the system, granting them legitimacy they otherwise lacked. The allegations go deeper, claiming that these vehicles were equipped with blue lights, emergency warning devices reserved for law enforcement use, taken directly from municipal stocks. Julius Mkhwanazi is accused of authorizing this installation, allowing Matlala to drive with these lights, which violates the National Road Traffic Act. Such actions not only breach regulations but also suggest a pattern of favoritism, where a private individual gains access to privileges meant for official duties. Nhlanhla Mkhwanazi emphasized that this was done through official channels in Egurhuleni, not privately, amplifying the severity of the misconduct. In response to these revelations, Julius Mkhwanazi applied for special leave on Tuesday, the 23rd of September 2025, confirming in an interview that he seeks this time away to allow the City Council to investigate the claims against him. The Ekurhuleni Metro has approved the leave, appointing Brigadier Okat Bezwidenhout as acting chief to maintain operations. However, the duration remains undisclosed, treated as a private matter between employee and employer. Julius Mkhwanazi maintains that the allegations are baseless and UN investigated, asserting that all procedures were followed properly. The situation has escalated with political parties in Egurulini pushing for stronger measures. The Democratic Alliance, African Transformation Movement, and Independent Ratepayers Association of South Africa tabled a motion for Julius Mkhwanazi's precautionary suspension, arguing that his continued presence risks undermining the department's credibility and the ongoing investigations. They point to the public concern generated by the Madlanga Commission's testimony, noting that even without final findings, the implications demand action to protect institutional integrity. The motion highlights how the alleged fraudulent registrations have damaged the municipality's reputation, posing threats to stability and public trust. Despite this, the Egurhuleni City Council rejected the suspension motion during their Thursday meeting on the 25th of September 2025. Isaac Berg, chairperson of the Independent Ratepayers Association, expressed disappointment, stressing the need for councillors to intervene when senior officials falter, especially in matters of national interest. This decision leaves Julius Mkhwanazi on special leave rather than suspended, but the council is still deliberating further steps, including potential disciplinary actions recommended by the Independent Police Investigative Directorate a year earlier. That recommendation followed reports of blue lights being handed over to Matlala in 2023, yet Julius Mkhwanazi was promoted to acting head instead of facing immediate consequences, until the Commission's spotlight intensified the pressure. These intertwined stories reveal a web of power struggles and potential abuses within South Africa's policing structures. The Madlanga Commission continues its hearings, with Friday, the 26th of September 2025, marking another day of testimony that could uncover more details. Mchunu himself is expected to appear, where he may address claims that President Ramaphosa endorsed the task team's disbandment, a point Nhlanhla has disputed, accusing Mchunu of shielding criminal syndicates. Van Rooyen's legal analysis strengthens the case against Mchunu, framing his actions as not just overreach but a direct threat to the separation of powers essential for democratic policing. The broader context includes ongoing concerns about criminal infiltration. Meanwhile, Sibiya's suspension stems from his role in executing Mchunu's directive without Nhlanhla's consent, highlighting internal hierarchies disrupted. Van Rooyen clarifies that deputies cannot bypass the National Commissioner, especially for orders outside ministerial scope. The Commission's findings will delineate ministerial powers, potentially reshaping how police entities interact with political oversight. For Mchunu, this could indeed signal the end of the road, as Van Rooyen's testimony nails his overreach in clear legal terms. As the Madlanga Commission presses on, Mchunu's future hangs in the balance, potentially hinging on whether his disbandment is deemed unlawful. Van Rooyen's expert view, drawing on constitutional provisions, provides a strong foundation for such a conclusion. This detailed account draws from multiple perspectives, illustrating how one blunder can ripple through institutions. The task team's disbandment delayed critical work, while Egurhuleni's issues highlight localized abuses. Together, they form a compelling tale of accountability in progress. Thanks for watching this news bulletin. Please share your opinion in the comments section. We would be glad to read and respond to your comments. Let's meet again tomorrow in our next strange story. Wishing you an exciting and adventurous weekend.